Bicycle fans may have to wait a while before they get their bicycles. That's after the U.S. Customs and Border Protection announced a surprise ban on Giant's products last week. Washington-based international and customs trade lawyer James Ransdell takes us through what happened, as well as the next steps a company might take in this week's holiday edition of Taiwan Talk.
So what's occurred here? It's an administrative action by U.S. Customs and Border Protection, which is the U.S. government agency that has jurisdiction over imports and exports, broadly speaking. So they've acted under a law that prohibits the importation of goods that are made by forced labor or convict labor. But this is a relatively early stage in that process. It's called a withhold release order. It's often abbreviated as a WRO, and it's based on a reasonable suspicion. Certainly, CBP is relying on some evidence, although they don't publish that evidence. So it's not something you can go online and look up and say, okay, here's specifically what CBP is looking at. Instead, they express it broadly in terms of some ILO indicators of forced labor. So you'll see in their news release, they name a couple that they think they have evidence of with respect to Giant. Now, although it's a relatively, let's say, early action in the process, the consequences are very significant. Based on this reasonable suspicion and based on the WRO that was issued, CBP is saying, we are not going to allow the products that we've described in this notice to enter the country. So if they come into a U.S. port, broadly speaking, they get detained. They're stuck there. They can be re-exported to another country. If they'll accept it, they can be destroyed. And those are really the options available if there's a product that falls within the scope of this WRO that enters the country.
What remedial? I'm sorry. Go ahead. Continue.
No, go ahead. So because it's early in the process, Giant will have an option and an opportunity to petition CBP to provide evidence of its own efforts, to investigate its supply chain, to remediate any sort of residual issues that it turns up, and to address them and basically prove to CBP's satisfaction that whatever problems CBP perceived when they issued this WRO, they've been addressed, procedures have been put in place so that they won't happen again. But it can be a very long process, and because CBP's information that they're relying on at this stage is not provided in full to Giant, they're working a little bit in the dark because they will need to sort of go back for sort of from top to bottom throughout their own supply chain at their production facilities in Taiwan and evaluate the labor conditions there and prove up to CBP that they've undertaken a thorough evaluation and not just internal involving third-party auditors and unannounced site visits and things of that nature.
Can Giant look at any precedents that have taken place in the past with regard to trying to clear their name over something like this?
It is. So it's a great question, and the natural starting point whenever a company is faced with this sort of administrative action is what has been done in the past and what can help here. And there really isn't much that Giant can look at in that respect because this area of CBP's practice is especially, let's say, not public-facing. They don't publish their decisions. They don't publish their rationale. This isn't a situation where you have like an administrative docket that has a lot of data and a lot of detail that you can look at and see sort of, trace through the decision-making chain and the evidence that was relied upon and what worked and what didn't. It's very opaque. And what CBP has published is, let's say, a general set of guidelines that was actually published this year, and it's about 12 pages long, so it has some detail, but also not exhaustive. And it basically instructs a company that's faced with one of these WROs to investigate themselves. They have the slight sort of direction giving that's provided by the particular ILO indicators of forced labor that are cited in CBP's WRO, but they're very general. They're very high level, and so it doesn't give a company any specifics necessarily to start with. So it's sort of a back to the drawing board situation to an extent of reviewing their own labor situation, reviewing their own supply chains, and then proving that out to CBP that, they've done this, they've done it thoroughly, they've done it seriously, and if there were issues that turned up, they've addressed them.
Do they have an ideal time frame through which they can provide the Customs and Border Patrol people with evidence so that they can lift this restraining order as soon as possible?
Yes. So there is not a set timeline that they are required to act in to petition with respect to this WRO to try to get CBP to modify it or remove it altogether. But historically, it takes a long time for a company to go through the process and get CBP to be sort of satisfied with respect to the situation. It's one of those scenarios where every situation is different. It's hard to extrapolate. And at least in this scenario, with respect to Giant in particular, we know that they've been looking into similar issues to some degree over the past year and a half, let's say. And so in that context, you would think that maybe they would be relatively better positioned. They would maybe have done some of the legwork already, that they could not be starting from scratch and not be, caught completely by surprise or, as if they hadn't thought about these issues. Like, there should be some groundwork there, but it is a process where they prepare their submission, CBP will review that submission, and then ordinarily there will be further back and forth between the agency and the company to try to get to a point where the agency's satisfied that, the company's really taken this seriously and has really fixed the problem that CBP perceived when they issued the WRO to begin with. But we're talking historically, more than a year worth of process.
Okay. Should this action put other Taiwan companies on the alert about their own practices? Will this, I guess what I'm asking is whether or not this is going to kind of raise alarm bells for other firms to be looking into their own practices to make sure that their books are clean, as it were.
Well, any firm that has or suspects they might have this sort of issue should certainly, clean house as best they can. Look into it. It's always better to be ahead of these sorts of issues than be on the receiving end of a WRO. So to that extent, just sort of like general best practices, absolutely. But is it the case that CBP historically has sort of, gone from like connected the dots, started with company A and then gone to company B and then company C in sort of the same space? We have seen that happen sometimes in the past. Like there was a period in 2020 where CBP issued WROs against several Pacific fishing vessels. And several of those were flagged in Taiwan. I think one of them was Taiwan-owned. And it was sort of like a thematic area that CBP was operating in for a little while. And so there is that precedent that exists just in terms of, where the agency's focus might be. It could be possible that CBP sees, the issues that prompted the WRO with Giant, and if it sees that as sort of a broader issue, there may be more to come. However, there's nothing in the WRO that was issued, this week that suggests that is necessarily the case. It's just a possibility that exists, but there's nothing, produced by the agency at this point that suggests, this is their plan going forward, or they really intend to do this necessarily.
Okay, let's speak more broadly now. This is coming at a very, very, very sensitive time for relations between Taiwan and the U.S. and global tariffs are an issue. Taiwan's tariffs, the U.S. tariffs towards Taiwan is an issue. Can you speak to that? Let's speak to the timing of this whole thing.
Yeah, of course. I mean, it's very natural, given the sensitivity of the moment, to look at these sorts of administrative actions, and Giant being a huge and important company for Taiwan, to sort of try to see that connection. I would not say, looking at this administrative action, however, that there seems to be a connection between the two. This does not seem to be sort of an element of the trade negotiations, let's say. They seem to be on two separate tracks. That the agencies that are pursuing the trade negotiations, right? They're led at this point by the United States Trade Representative and the U.S. Department of Commerce. U.S. Customs and Border Protection is a different entity, and it's within a different agency. So we wouldn't necessarily expect them to be coordinating at this sort of granular level. It's likely just the result of sort of old-fashioned administrative legwork and a work stream that was probably in the works for some time.
You were listening to Washington-based international and customs trade lawyer James Ransdell. I'm Hope Go. Thank you for tuning in.